case briefs, and so much more. LSData's got what you're looking for.
In a 1972 trademark infringement case, Coca-Cola Company v. Gemini Rising Inc., the United States District Court for the Eastern District of New York granted a preliminary injunction in favor of the Coca-Cola Company. The defendants, a New York corporation, had been selling posters that intentionally copied the Coca-Cola trademark by replacing cola with "-ine", resulting in the phrase "enjoy cocaine". Over 100,000 copies of this poster had been sold. Coca-Cola pursued legal action against the defendant for trademark infringement, seeking injunctive relief on the grounds of harm to their business reputation and unfair disparagement of their product. The defendant attempted to argue against the court's jurisdiction and the plaintiff's allegations. However, the court sided with Coca-Cola and granted them a preliminary injunction, ordering the defendant to temporarily discontinue selling the particular poster that imitated the Coca-Cola trademark. Additionally, Coca-Cola was required to provide a $25,000 bond to cover any potential costs or damages incurred by the defendant as a result of the injunction. The court ruled in this way to protect Coca-Cola's name and reputation, finding that the balance of hardships favored the plaintiff in this case.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.